Alright everyone, I need your full attention because what I'm about to share could save your family hundreds of thousands of dollars. Here's the reality we're facing in 2025. Nursing home care now averages $9,500 per month nationally, while Medicaid still limits you to just $2,000 in assets to qualify for help. That means a typical middle-class family with $400,000 in savings faces complete financial devastation. But there's still hope if you understand the specific strategies I'm going to reveal today. I'll show you concrete steps families can take right now to protect their nest egg using legal asset protection methods and Medicaid planning techniques that actually work. The costs keep rising and the protection windows keep getting shorter, so we need to start with the numbers. The shocking reality of 2025 nursing home costs. Let me ask you something before we go any further. What do you think it costs per month for nursing home care in 2025? I want you to think about that for a second. Maybe you're thinking $5,000 a month. Maybe $6,000. Those numbers might seem high, but I need to tell you something that's going to shock you. The 2025 median cost for a semi-private room is $9,197 per month, while a private room runs $10,326 monthly. That's right, over $10,000 every single month for a private room. Now that number alone should make you sit up and pay attention, but it gets worse. Much worse. In high-cost areas like New York, California, Connecticut, and parts of Massachusetts, we're seeing nursing home costs that exceed $15,000 per month. Some facilities in Manhattan are charging over $18,000 monthly. Think about that for a moment. $18,000 every month just for a bed, meals, and basic care. The jump from where we were just 3 years ago is staggering. In 2022, the national average was around $8,200 monthly. That means we've seen an increase of over 15% in just 3 years. This isn't normal inflation we're talking about. This is a crisis that's hitting families across America and destroying life savings at record speed. What drove these massive increases? 2 major factors created this situation. First, inflation hit every aspect of nursing home operations. Food costs went up, utility bills skyrocketed, insurance premiums increased, and maintenance costs for aging facilities climbed substantially. But the bigger driver has been the staffing shortage that began during the pandemic and never recovered. Nursing homes lost thousands of workers during COVID, and they haven't been able to replace them. The facilities that stayed open had to increase wages dramatically to keep staff and attract new workers. Many facilities now pay overtime rates just to maintain minimum staffing levels. Some are offering signing bonuses of $10,000 or more just to get certified nursing assistants in the door. All of these increased labor costs get passed directly to residents and their families. Here's something most people don't understand about Medicare coverage. Medicare only covers short-term skilled care up to 100 days, not long-term custodial care. Custodial care means help with daily activities like bathing, dressing, eating, and taking medications, which is what most people in nursing homes actually need. The reality is that most families are completely unprepared for these expenses. The Employee Benefit Research Institute found that only 23% of Americans have any long-term care insurance. That means 77% of families will pay these costs out of their own savings or rely on Medicaid if they qualify. Let me give you a real example of how quickly these costs destroy family wealth. Take a typical middle-class couple with $400,000 in retirement savings. The husband develops dementia and needs nursing home care at $9,500 per month. That's $114,000 per year. Even if the wife continues living at home with minimal expenses, their savings will be completely gone in less than 4 years. $400,000 gone. But remember, that's using the national average. In higher cost areas, that same family's savings disappear even faster. At $15,000 per month, we're talking about $180,000 per year. Their $400,000 lasts just over 2 years. 2 years and their life savings are completely wiped out. Here's another example that really drives home the reality. I worked with a family last year where the wife needed nursing home care for 6 years before she passed away. 6 years at an average cost of $10,200 per month. That's over $730,000 in nursing home expenses. They started with $850,000 in assets. By the time she passed, they had less than $50,000 left. The speed at which these costs consume savings catches families off guard every single day. Many people think they have enough money to last their lifetime, but they never calculated nursing home expenses into their retirement planning. A comfortable retirement of $5,000 per month in expenses suddenly becomes $14,500 per month when one spouse needs nursing home care. And the costs keep climbing every year. Industry projections show semi-private rooms will exceed $10,500 per month by 2030. Families planning for retirement need to factor in potential nursing home costs that could reach $20,000 per month in high-cost areas within the next decade. Most people assume they'll never need nursing home care, but the statistics tell a different story. The Department of Health and Human Services reports that 70% of Americans over age 65 will need some form of long-term care services. Of those, 35% will need nursing home care at some point. That's more than 1 in 3 people. The window for protecting assets from these costs is narrowing every year. Medicaid has strict rules about asset transfers, and any planning must be completed years before you need care. The longer families wait to implement protection strategies, the fewer options they have available. But here's what gives me hope and why I'm doing this presentation today. There are still legal methods that work to protect family wealth from these devastating costs. Families who understand these strategies and implement them properly can preserve their life savings even when nursing home care becomes necessary. The key is understanding that protection planning must happen before the crisis, not during it. Understanding these 2025 nursing home costs is your first step toward protecting your family's financial future. Once you grasp the magnitude of these expenses and how quickly they can destroy decades of savings, you can begin to appreciate why asset protection planning has become essential for every American family. The families who protect their wealth aren't the ones with the most money to start with. They're the ones who understand the threat and take action before it's too late. But knowing the costs is only half the battle. The bigger challenge most families face is understanding how government assistance actually works and why the qualification rules seem designed to trap middle-class families in an impossible situation. How Medicaid's 2025 rules create a wealth trap. Medicaid's asset counting rules create what I call a wealth trap that catches almost everyone off guard. Let's start with the basic asset limits for Medicaid eligibility in 2025. If you're single and applying for nursing home Medicaid, you can only keep $2,000 in countable assets. That's it. $2,000. Think about that for a moment. You could have worked for 40 years, saved diligently, built up a retirement account worth $300,000. And Medicaid says you need to spend down to just $2,000 before they'll help pay for your nursing home care. The rules get more complex when you're married. Medicaid recognizes that the healthy spouse staying at home needs resources to live on, so they created something called the Community Spouse Resource Allowance. In 2025, this allowance allows the healthy spouse to keep approximately $128,640 in countable assets. The exact calculation works like this. Medicaid takes 50% of the couple's total countable assets, and if that amount falls between $31,584 and $157,920, that's what the community spouse gets to keep. Here's an example that shows how this works in practice. Take a married couple with $400,000 in total assets. When the husband needs nursing home care and applies for Medicaid, they're allowed to keep $157,920 for the wife. The remaining $242,080 must be spent down before Medicaid will pay for the husband's care. At $9,500 per month for nursing home costs, that spend-down period lasts about 2 years. 2 years of paying privately while burning through their life savings. But the asset limits are just the beginning of Medicaid's wealth trap. The real trap comes from what's called the look-back period. Medicaid doesn't just look at what you own on the day you apply. They conduct a 5-year financial investigation into every transaction you've made. This 60-month look-back period means Medicaid reviews bank statements, investment account records, property transfers, and any gifts you've made going back 5 full years from your application date. Medicaid reviews 60 months of financial records for transfers over $1,000. Any gift, sale below market value, or transfer to trusts can trigger penalties. The penalty calculation works like this. Smaller amounts typically incur 1-month penalties per $5,000 transferred, while any gift over $300,000 triggers a 5-year penalty period. So if you gave your daughter $50,000 3 years ago to help with her house, you'd face a 10-month penalty period where you're responsible for paying the full nursing home costs even though you've already spent down your assets to qualify. I see families get caught by this all the time. A grandmother gives each of her 3 grandchildren $15,000 for their education. That's $45,000 in gifts. Later, when she needs nursing home care, those gifts create a penalty period that could last 9 months depending on local nursing home costs. The family thought they were being generous and helping with education expenses, but Medicaid treats those gifts as attempts to hide assets and imposes penalties. Property transfers create some of the biggest problems. Many families think they can transfer their house to their children and protect it from nursing home costs. But if you transfer your house during the look-back period without receiving fair market value, Medicaid calculates a penalty based on the home's value. A house worth $300,000 could trigger a penalty period lasting over 2 years in many areas. Here's what makes this particularly harsh. The penalties don't start until you would otherwise qualify for Medicaid. So you spend down all your countable assets to meet the $2,000 limit, apply for Medicaid, and then discover you face months or years of penalties during which you must pay privately for nursing home care. You're broke but still don't qualify for assistance. I worked with a family last year where this exact scenario played out. The parents had transferred their house to their son 4 years earlier thinking they were planning ahead. When the mother needed nursing home care, they spent down their savings to qualify for Medicaid. But the house transfer created an 18-month penalty period. The family had to come up with over $170,000 to pay for nursing home care during the penalty period. Money they didn't have because they'd already spent their savings. The all-or-nothing nature of Medicaid qualification makes planning extremely challenging. You either qualify completely or you don't qualify at all. There's no partial assistance, no sliding scale based on income or assets. You meet all the requirements or you pay privately until you do. What frustrates families most is that these rules seem designed to force people into poverty before providing assistance. You work your whole life, save responsibly, maybe help your children along the way, and then discover that normal family financial transactions disqualify you from the very program designed to help with long-term care costs. But here's the important point that gives me hope for families. There are legal strategies that work within these rules rather than against them. The key insight is understanding that Medicaid planning must happen before you need care, not during a crisis. Families who plan ahead using the right legal tools can protect their assets while still eventually qualifying for Medicaid when care becomes necessary. The rules create a trap for families who don't plan, but they also create opportunities for families who understand how to work within the system properly. The difference between families who lose everything and families who protect their wealth often comes down to timing and knowledge. 2 families with identical circumstances can have completely different outcomes based on whether they understood these rules and took action before the crisis hit. The 2-family story that changes everything. Let me tell you about 2 families that demonstrate exactly how these outcomes play out in real life. Both families had worked their entire careers, saved responsibly, and built up retirement assets worth about $700,000, including their homes. Both couples had similar incomes from Social Security and pensions, and both husbands developed dementia at age 78 requiring nursing home care. But what happened to these 2 families was completely different. The first family, Harold and Nancy, followed what most people would consider traditional financial planning advice. They kept their house in both their names, maintained their savings in joint bank accounts, and had their retirement accounts set up with each other as beneficiaries. When Harold started showing signs of dementia, Nancy became his caregiver at home for about 2 years. But eventually his condition deteriorated to the point where he needed professional nursing home care. Harold entered the nursing home when monthly costs were running about $8,400. Nancy continued living in their home, managing on her Social Security and Harold's pension. But every month, thousands of dollars came out of their joint savings to pay for Harold's care. Over the 3 years Harold lived in the nursing home, the family paid out $252,000 in care costs from their $400,000 savings account. Harold passed away, and Nancy thought the worst was behind her financially. But 6 months later, Nancy started having her own health issues. At age 82, she needed nursing home care herself. With their remaining savings depleted and facing monthly costs of over $9,000, Nancy had to apply for Medicaid assistance. When Nancy qualified for Medicaid, the state began paying for her nursing home care. But when Nancy passed away 2 years later, the state had spent approximately $300,000 on her Medicaid nursing home benefits. Under Medicaid estate recovery rules, the state filed a claim against Nancy's estate for the full amount they had paid for her care. The estate had to sell the family home to pay this claim. After real estate commissions and other estate settlement costs, Harold and Nancy's children inherited almost nothing from their parents' original $700,000 estate. Now let me tell you about the second family, Michael and Pamela, who had the same asset profile and similar circumstances. But 5 years before Michael developed dementia, when both were 70 years old and in good health, they made a decision that completely changed their family's financial future. Michael and Pamela learned about the risks of nursing home costs to family wealth and decided to meet with an elder law attorney who specialized in Medicaid planning. After reviewing their situation, the attorney recommended creating an irrevocable income-only trust. Michael and Pamela transferred their home and most of their savings into this specialized trust structure. They retained the right to receive all income generated by the trust assets, which meant they could still access interest, dividends, and any rental income. The trust was designed so that after 5 years, the assets would no longer count as available resources for Medicaid eligibility purposes. When Michael developed dementia at age 78, the family faced the same difficult decision about nursing home care. Michael entered a nursing home with monthly costs identical to Harold's situation. But here's where Michael and Pamela's advanced planning paid off dramatically. Because more than 5 years had passed since they created the trust, the assets inside the trust no longer counted for Medicaid eligibility. Michael qualified for Medicaid benefits immediately. The state began paying for his nursing home care from day one, and the family didn't have to spend down their life savings. Michael lived in the nursing home for 3 years, just like Harold. But instead of spending hundreds of thousands of dollars of their own money, Michael and Pamela's family paid nothing out of pocket for Michael's care. Medicaid covered 100% of the nursing home costs. When Michael passed away, Pamela was able to continue living in the family home because the trust allowed her to remain there for life. The trust assets that had been protected during Michael's nursing home stay remained intact for Pamela's use and security. Later, when Pamela developed her own health issues and needed nursing home care at age 82, she also qualified for immediate Medicaid coverage. The trust assets still didn't count as available resources because they remained properly structured within the irrevocable trust. When Pamela passed away after receiving Medicaid-covered nursing home care, there was no estate recovery claim against the family home or savings. The trust had protected these assets from being considered part of Pamela's countable estate for Medicaid purposes. Michael and Pamela's children inherited the full value of their parents' $700,000 estate. Think about this comparison for a moment. Both families started with identical assets and faced identical circumstances. Both husbands developed dementia at the same age and needed the same level of nursing home care for the same length of time. Both wives eventually needed nursing home care themselves. But Harold and Nancy, who kept everything in their own names following traditional advice, saw their entire life savings consumed by nursing home costs and Medicaid estate recovery. Their children inherited almost nothing. Michael and Pamela, who implemented protective planning 5 years before they needed care, preserved their full $700,000 estate for their children while receiving the same quality nursing home care covered by Medicaid. The difference wasn't luck, income levels, or investment performance. The difference was understanding how Medicaid's rules work and taking legal action to protect their assets before a health crisis occurred. Michael and Pamela gave up direct ownership of their assets but retained beneficial use through the trust structure. This strategic sacrifice of ownership allowed them to preserve their family's wealth while ensuring they would qualify for Medicaid benefits when long-term care became necessary. This story illustrates why most families struggle with asset protection planning. They assume that standard estate planning tools will protect them from nursing home costs, but those traditional approaches often fail completely when long-term care becomes necessary. Why traditional estate planning fails for long-term care? The most common mistake I see involves families who think their existing estate planning already protects them. People come to me saying they have their revocable living trust set up, everything's organized, and they believe they're protected from nursing home costs. But revocable trusts don't shield assets from Medicaid because you retain control. The 2025 limit is still $2,000, even if assets are in a revocable trust. The misconception about revocable living trusts creates enormous problems for families. They spend thousands of dollars setting up these trusts thinking they've protected their assets, but revocable trusts serve completely different purposes. The primary benefit of a revocable living trust is avoiding probate when you die and making asset transfers easier for your beneficiaries. But because you retain complete control over the trust assets during your lifetime, Medicaid treats those assets exactly the same as if you own them directly. Here's how this works in practice. Say you have $300,000 in a revocable living trust. When you apply for Medicaid nursing home benefits, the caseworker counts that entire $300,000 as an available resource. It doesn't matter that the money is technically owned by the trust. Since you can revoke the trust at any time, withdraw money whenever you want, and change beneficiaries without anyone's permission, Medicaid considers you the true owner of those assets. Harold and Nancy discovered this reality when Harold needed nursing home care. They had established a revocable living trust years earlier and transferred their house and savings into it, believing this provided protection. When Harold entered the nursing home, they learned they'd have to spend down almost all their trust assets before qualifying for Medicaid. The trust provided no protection whatsoever against nursing home costs, and their $700,000 estate was consumed by care expenses and eventual Medicaid estate recovery. Joint ownership creates similar problems that catch families off guard. Many couples think that putting assets in both names provides some protection, but Medicaid has specific rules about jointly owned property. When a married couple applies for nursing home Medicaid, all countable assets are considered jointly owned regardless of whose name appears on the accounts. Both spouses have equal ownership rights to everything, and the assets get counted toward the couple's total when determining Medicaid eligibility. Beneficiary designations don't help either. Some families think they can protect retirement accounts by naming their children as beneficiaries, but Medicaid looks at who controls the account during the owner's lifetime. If you can withdraw money from your IRA or 401k account, those assets count as available resources for Medicaid purposes. The fact that your children will inherit the account after your death doesn't change how Medicaid treats it while you're alive. This creates what I call the control versus protection dilemma that every family faces. Traditional estate planning focuses on maintaining control over your assets while you're alive and ensuring smooth transfers after death. But Medicaid planning requires the opposite approach. To protect assets from nursing home costs, you typically need to give up direct ownership and control over those assets. The timing of asset transfers makes this dilemma even more challenging. Families who try to protect assets after a health crisis has already begun face severe penalties under Medicaid's lookback rules. Any transfer of assets for less than fair market value during the 5 years before applying for Medicaid can trigger penalty periods where you're ineligible for benefits. I see this constantly with families who panic when one spouse receives a dementia diagnosis. They rush to transfer their house to their children or move money into their kids' accounts, thinking they're protecting assets. But these last-minute transfers actually make their situation worse. The transfers don't provide protection because they happen during the look-back period, and they create penalty periods that force the family to pay privately for nursing home care even after they've given away their assets. Gift-giving strategies that work perfectly for tax planning often create disasters for Medicaid planning. The IRS allows annual exclusion gifts of up to $19,000 per person in 2025 without triggering gift tax consequences. Many families think these tax-free gifts are also invisible to Medicaid, but that's completely wrong. Medicaid doesn't recognize the annual exclusion. Every gift during the 5-year look-back period, regardless of amount, gets counted when calculating penalty periods.